Good afternoon, Dr. Saigal. How are you? Sir, you are mute.
Please unmute your mic.
Is it okay now?
Yes, yes.
Yeah.
Hi,
Good
hi,
e-
hi.
Hi.
Thank you for joining.
Good
Pleasure,
afternoon.
pleasure.
Second sir, good afternoon. I'm Dr.
Good
K.S.
afternoon, Doc.
How are you?
I'm fine. Thank you. How are things at your end?
I'm fine, sir.
That's great, great. Let's make something very good for the audience today together.
Right. Absolutely. Yeah.
Sweetie.
Dr. Ane, I'm unable to see this thing, upload or you share the presentation. This
Uh, Other day, you mean?
no. I'm requesting Dr. Ane.
Uh-huh.
I am unable to see. There is some button or some indication to share the screen or something like that.
Just a
Sir,
minute.
in the right bottom corner, you have one option.
Just a minute. Full screen. Okay. Report is problems. Right side column.
It says present now, sir.
नहीं ऐसा is not. It's nothing like that. Piyush Vaman is presenting like this.
Yes, sir. Yes, that only, sir.
Okay. Thank you. Okay, thank you.
So they will stop presenting in some time. Then, sir, you can present there.
Maybe I'll speak and maybe when it is required, then I will share some points.
Yes, sir. Yes,
Yeah.
sir. So initially, Piyush will be presenting the details about the session,
Mm-hmm.
and at the time of introduction of the speakers photograph and the speaker's profile will be shared.
Mm-hmm.
And after finishing the introduction of the speaker, we will hand over the session to both the speakers for the panel discussion. At that time, you can share your presentation as per your turn, as per your convenience.
Right. Thank you.
So I do not have any presentation today. I'll be just discussing whatever questions are asked, and then we'll be rather discussing accordingly.
Okay, sir, as per your convenience.
Yeah.
Shall we start?
Yeah, absolutely. We are ready.
I'm okay. Yep.
You people are awaited. Let us check whether these people are joining in the next 1 or 2 minutes. We will start. Piyush, are you giving the presentation? Yeah. A warm welcome to all of you from Team SPC for this TechWeb3 sponsored national level workshop on strategic issues in IPR and innovation. Today, we are obliged to receive the expert inputs from Dr. Kardam and Dr. Sehgal. So Dr. Kardam and Sehgal are available with us for the panel discussions. And Dr. Kardam, he is a senior joint controller of head office of Patent Office of India and worked over there for the 37 years and visited many countries across the world in the context of IPR and the peripheral dimensions. And with reference to the second speaker, Dr. C.K. Sehgal, I have already, we all of us have already listened his speech. He was also he is already formally introduced to you. At this moment, I would like to introduce Dr. Kishan Kardam in detail. Dr. Kishan Kardam is a former head at Patent Office Delhi, former senior joint controller of patents and designs. He has worked in Indian Patent Office for last 37 years and held various positions. He has superannuated on 31st July 2019. Before his superannuation, he was holding the post of Senior Joint Controller of Patents and Designs and headed the Delhi Patent Office and the Indian ISA and IPEA. He also did post-graduation in organic chemistry. He has also studied law from Delhi University and hold master's degree. He has also done PhD in intellectual property law from Delhi University. He has published several research articles in various journals on the topic related to intellectual property. When India joined WTA and TRIPS, he had actively participated in process of amendment to the Patents Act in 1970 in the year 1999, 2002, 2005, and the revisions in the patent rules. He was also one of the members of the task force for Traditional Knowledge Digital Library for protecting Indian traditional knowledge and played important role in designing the structure for electronically capturing the information in the Traditional Knowledge Digital Library and Traditional Knowledge Resource Classification by assigning the international classification in order to make Traditional Knowledge Digital Library searchable. Thank you for this remarkable contribution into the IPR domain. He had also conducted 6 months research study in Japan about utility model and its economic and technological significance to India under WIPO sponsored program. He also widely traveled in many countries and visited their patent offices such as USPTO, EPO, JPO, SIPO, GPTO, My IPO, etc. to understand their IPR systems. He was actively involved in the preparation of Manual of Patent Office Practice and Procedures, Patent Office Practice for Internal Working Examination Guidelines for the inventions related to biotechnology, traditional knowledge, chemicals, pharmaceuticals, and computer-related inventions. He has also represented India on many occasions in WIPO in respect of Standing Committee on Patent Law, PCT Working Group, meetings of international authorities, WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, etc. I welcome Dr. Kardam, and now I shall introduce once again Dr. C.K. Sehgal for the people who joined this session first time and missed out some of the sessions earlier. Dr. C.K. Sehgal is a managing partner in Sehgal IPR Services. Dr. Sehgal has 30 plus years of corporate experience in various functions in R&D, regulatory, marketing and IPR, etc. in specialty chemicals, petrochemicals, polymers and pharma sectors. He has held responsible positions in multinational companies. He worked in USA as a IPR attorney in Connecticut, and he performed hundreds of training programs and offered the necessary consultancy for drafting the patents. With reference to the education, he has completed MSc Organic Chemistry. He has also completed PhD, and he completed his postdoctoral fellowship of 2 years in Exeter University, United Kingdom. He completed his second postdoctoral fellowship of 2 years in Warwick University, United Kingdom. Effectively, he is managing this IPR services LLP company Sehgal IPR Services LLP for IPR activities and so on. So he is actively involved in the IPR domain and offering his services to the corporate world. We have we have Dr. C.K. Sehgal as the second panelist for the today's panel discussion. A warm welcome to Dr. Sehgal. Now we will start with the panel discussion. So I will start with the first question. The first question goes to Dr. Kardam first. Sir, about the academic institutions, how can we promote intellectual property in the academic institutions, and how to maintain the intellectual property, how to preserve it, how to promote it in the academic environment? Yes, sir. Sir, you are not audible, sir.
Thank you so much. First of all, I would like to convey my sincere thanks to you, Dr. Rane, for inviting me for this particular program, very, very important program. And it's my pleasure to associate with all of you in this particular important program. So the academic institutions, if we look at globally, in IPR, especially in patent, there are many universities from US, Japan, China. They are in top 100 universities which are getting patent or even protecting other IPR. But there is none from India so far. I mean, India is, I think the IP system is existing since 1856. So more than 150 years already over, but we have not taken the IPR very seriously. And obviously because our previous system, the past system, was to share the knowledge and give it to the world free of cost. We never realized the importance of IPR monopolizing the knowledge. Where the Western world started very early monopolizing the things and protecting their knowledge in the form of monopolies. So they are much ahead of us, but India is continuing to do the innovation, but not taken seriously until this TRIPS agreement came into force. When we realized there is a competitive world where one need to protect the innovation. And more so when the Halli case came into existence, then again India woke up to the misappropriation of traditional knowledge, and that's how India woke up to the intellectual property regime. So again I come back to the universities. So universities again we have not realized the potential, because universities there is a huge potential in the university technical institutions to generate IPR, because you have the science, you have the faculty members, you have the research students, even postgraduate students. They need to, they are doing their research projects, but no one is there to guide them to how whether there is any IP lies in their research. When I was in Japan, then I saw the system existing in Japan. So where I went for 6 months course when some students were doing IP, or some students were doing post graduation in various field of technology. So what they used to do it, that they used to make a presentation every 6 months, every fortnightly. to review their progress of the project, and then they say, is there any intellectual property created in it? And that's the way how they tap early. I mean, they recognize early importance of IPR, and that's how they encourage the student to file the IP application. Then maybe for patent, or maybe a small utility model, or maybe a small any design in that, and then if they found it very commercial, then they go for the registration for the trademark and other kind of thing, so that's how we should do it. That is the way. But I mean, just on this particular point, I would just share one slide. Then you will see the what university has to do it. How to share it. The Chrome, how to share this one?
Sir, at the right hand side, you will
Then
find present now. You will
Then
find present
shall
now.
I open the slide first or then share it?
Yes, sir. Yeah, it will be better if you open the slide and
I
then
opened
you
it.
go to me, and the right bottom right corner there is a present
Present
now.
now. Yeah. So
Click
the
it.
Chrome
When you
tab.
click it,
Mhm.
you will get the three options: your entire screen, window, and Chrome tab.
Okay.
You can select your entire screen,
That I selected.
entire
Then
screen, and now again go back to your presentation. So your presentation will be present, available on the screen.
okay. Okay. So this is the slide. Are you able to see it?
No, sir.
So same issue what I had before yesterday.
Okay. Sorry. Yeah.
I think instead you can send it to Dr. Rane and they probably can put it down.
Yes, yes. You can send it to me or organizing team.
What I did
Anybody.
yesterday and it was very effective.
Just a minute.
It is getting presented, sir. Yes, yes. It will be available now. It will be available. It will be available.
You are you able to see it? What is happening?
No, no, not yet.
Sir, you need to go back to your slide now.
Okay.
Yes.
Just a minute.
Yes, sir.
Yeah, yeah. It's
Available.
okay.
Done,
I
done.
will-
Done,
How
done.
yeah. So what you should do, what the institution should do, that first of all they should take stock of their IP application, whether any IPR is filed or not, and then they should also take a stock and review of the PhD thesis. There are a lot of PhD work being done in the institutions or universities. Then there are so many research projects sanctioned to faculty by various funding agency. Also, there are many books written by the faculty, and track on going PhD work and project work to examine the possibility of obtaining patent in that. And then take stock of any patent if you have filed or design registration received. Then prepare an inventory of IP and IPR. Then you go for a commercialization. Maybe you can go yourself, but I think when you are busy in the faculty and teaching, it is impossible to commercialize yourself. So what you should do, you look for the partner, look for the people who can commercialize, so to whom you can license your intellectual property. and they will be the people who can exploit it commercially. And this can be done by way of licensing. It may be exclusive licensing, it may be non-exclusive licensing, or maybe a sole licensing. So you choose yourself what kind of mode you want to license it. And there are other things also, like whether you want to take a one-time royalty on the IPR we are going to license, or maybe when you go the royalty plus based some incentive based on the product sale, of the percentage of the sale. So there are many various ways of licensing the intellectual property. And again, if you are not able to do it, then you can have a small cell where you can appoint one technology transfer officer, TTO. So maybe a cell will be, I think, good idea in the university to establish, which can do this kind of work, because there are many professor or maybe faculty members who are not very keen to, take up this kind of job, and because they are more in research, more in teaching. So I think that work, I think they love to do it, but not this IPR licensing transfer technology. Maybe this cell can be a very useful thing which can coordinate between the student, maybe in reviewing the research projects, reviewing the PhD thesis, or reviewing even when somebody is doing post graduation, they are also asked to make some research work, some kind of paper they have to present, they have to do certain things. So those kind of things can be reviewed by the officer or the person who is in charge of the IP cell, and then he can find out whether this is good for patent or maybe good for design. Because every aspect of IP is important. It is not just patent. So what is patent? I think in entire session, you must have heard from various speakers about kind of, intellectual property. So just give you just example of that. See, these are the kind of intellectual property. One is patent. Patent, in fact, is related to the invention. It may be a product or maybe a process which is new, which is inventive, and have some industrial application of it. So when you are going to solve some problem which are faced in day-to-day work, while working with certain equipment or maybe working with a process, so you find some problem, and how that problem is resolved, that you conduct some research. So based on that outcome, how to improve, then that new finding may be useful as an invention for protecting by patent. So, and there are other part of innovation is the outer shape of the product. The product may be the old, but its shape is different, or maybe a design, or any kind of design where shape or outer look is different than the existing one. That is a good, IP for protecting it. So maybe by industry. So outer shape or a configuration of a article which is applied to the product is a good subject matter or good intellectual property to be protected. When we sell this patent product or invention, there are, the brand by which you sell, that is protected by trademark. And as I said, the professor writing many books, or even sometimes they write a short note or maybe a key, one says that the small book, very quick, information, that is also a protectable under the copyright. Whatever you do it is a protectable. When you write even a guide in a simple form. Maybe the formula are known, but the way you have written those, when you have interlinked the ideas, the formulas, then that can be protected through copyright. So another kind of intellectual property is the geographical indication. That means the product which may be a agriculture product, or maybe a synthetic product, or maybe a man-made or handicraft product, which can be protected under geographical indication, where the product has some characteristics related or the attributes which are from the particular area of the area of or region of a particular state of the country. So they are all those properties or attributes are associated with that particular region. So those products which are having a distinct characteristic which are associated with the origin of the product are protectable under copyright. Oh, sorry, geographical indication. Then there is a plant variety where you are developing new seed or plants varieties, where some breeders have changed. They are breeding the plants and they come out with a new plant variety. They are protected under the plant variety. And there are certain layout design of or integrated circuit. The new circuit in the electronic field, they are protectable under under copyrights. Under the layout design act. So these are the few intellectual property which are protectable. So I think all of them have a link to university or academic institution. I think they should focus on these, but there is a need for regular, I think, regular review of those things, all the intellectual property by a particular set. And apart from that, there should be a IP policy to be established by technical institutions, so that the people who are owning, the student, maybe the faculty members who created it, they can be incentivized. So if they are incentivized, they will feel motivated, and they will go for further research, where they can be inspired to go for further research, because that generates some income. And maybe in US and other countries, many professors have become entrepreneurs and sometimes they have shared or they have licensed their technology, and they are earning a lot. So this is a good, the universities have good potential, I think, or institute, any academic institution, they have a good potential to protect IPR more than the company actually. So companies, they are focusing on a particular field of technology, where the university have variety of field of technology, where you have a faculty of computer science, where you have faculty of electronics, where you have faculty of pharmaceutical, or different field of technology, where the company is focusing on only one technology, or maybe out of technology one specific product. So the university need to inspire their faculty members, they need to incentivize them and have a regular review of the research work. I think that is how they should promote their intellectual property. That's what I think.
Thank you, Dr. Kardam, for the very great elaboration and discussing all the relevant dimensions connected with the IPR world of academic institutions. Now, with reference to these, what are the different steps taken by Government of India to create the awareness of the IPR to be created, preserved, improvised by the Indian institutions? What government is doing in the context of this? What and how these different schemes or different drives are launched and particularly reached to the even to all sections of the society on all the different institutions, even the institution which is remotely located somewhere in the or in some of the state, how the drive or scheme can be reached to them? Are there such kind of schemes available, some drives available, some initiatives available from Government of India?
Yes, there are schemes. Actually, when I was there, so we started the national campaign on intellectual property. So every year we organize IP awareness program in collaboration with industry associations such as FICCI, SOCHM, and CII, then TSG chambers, and there are so many industry associations. So these programs are funded by government and patent office partially, and we have a different target audience. Like the one of the targets are the university and technical institutions, and we also target MSME and the industry. There's certainly our focus is on the awareness to be created in university and academic institutions. And as you know, in 2016, Government of India released a national IPR policy, and under one of the main objective of this policy, one of the out of 7 objective, one of the objective is to promote, to create awareness program in the country. So beside the IP office, the government has also created one more cell in the Department of Industry Policy and Promotion, DIPP, Ministry of Commerce and Industry, that is known as CPAM, Cell for Intellectual Property Promotion and Management. And this department is now focusing on creating awareness of IP, especially the universities, and there is a tinkering lab. There are tinkering labs. There are certain schools are declared tinkering labs where incubation facilities available for the student. So those schools are targeted by CPAM. So their aim is to create at least 4,000 awareness programs in a year in such a school. So there is a big for this particular program, and the government has a lot of budget on creating this program. So this program is also now focusing, and the CPAM is also now associating AICT in creating awareness in technical institutions. So this CPAM and IP offices both have different target to focus on IP awareness programs. So certainly, in case you are interested, in Mumbai we have an office of the Controller General, and each office is given the responsibility to create awareness in various states. So state-wise, there is a division of offices, which state they are going to focus every year. So every year, I think we focus, we conduct. Each office is conducting 100 IP awareness program every year, and they are targeting around 15 states, each office. So that is how the IP awareness is being created by the government. Maybe
Thank you, Dr. Kardam. Now I would move towards Dr. Sehgal. Sir, the questions are like this. Particularly, how can we protect intellectual properties abroad, and what are the procedures connected for that, and what is the scenario of our Indian patents across the globe? Particularly, what is the mechanism? Will you please shed light on this?
Yeah, as a matter of fact, if at all anybody from India who wants to file a patent, as per the Indian patent law, initially it has to be filed within India. Though there's a provision that if at all the party wishes to file outside India first, there's a provision they have to inform Indian Patent Office first and seek a permission under Form 25. Then they can file abroad also directly. Once a patent application is filed, after 4 weeks, they can file anywhere else outside India, taking priority of earlier filing in India. And this has to be done within 12 months from the date of application in India. However, as I explained during my talk yesterday also, there's a provision under the Patent Cooperation Treaty that in patent application after filing in India can be filed in WIPO as PCT application, which gives a wider window of filing anywhere else of 30 months vis-a-vis only 12 months if it is based on the priority in India only. And then for filing abroad, it has to be filed through a patent agent from that local jurisdiction. However, in Singapore, it is not so. In Singapore, it can be filed by anybody online also. But in all other jurisdictions, it has to be through a local patent agent or attorney. Indian attorneys, they do provide that service since they have got the associates in almost every global jurisdiction. And the process is the same as in India. First, it has to undergo examination. You have to pay requisite fees, etc. All those things. Process as such is primarily very similar to whatever is in India. So this is how one can rather look at acquiring IP outside India in various jurisdictions, wherever they feel they have got a business interest. As regards institutions, one has to look at it. Once a patent application is filed in India by an Indian institution, then they have to go through PCT application. When you say PCT application, it has to undergo examination by an recognized international search authority. India is also an ISA at moment, and if at all you have to get it examined by US or EP or Austria, it is very expensive to the extent of more than $3,000. However, in India, the fee is very minimal, 10,000 rupees only. Once it gets examined in India, that also provides a strength of merits of one's invention. And one can take a call accordingly whether what is the chances of getting it granted outside India or in other jurisdictions also. Accordingly, a decision can be taken.
Thank you, sir. Thank you.
Besides
There
this-
is one more question.
Yeah.
Sorry.
Yeah,
Just
there
to,
is one
just
more
to-
question.
Dr. Rane, just to supplement Mr. Sehgal, Dr. Sehgal, what he explained about the PCT and for patent filing, there is similar, TT on trademark, there is a MADIT protocol. So if you want to protect your trademark outside India, there is a similar procedure existing. So that is known as MADIT protocol, under which you file first in India and then designate the member countries to file application abroad. So the similar system is existing for trademark also. But there is another treaty known as Hague Treaty, but it is not yet, India is not yet a member to that. So we are still unable to file the design application internationally using this international treaty, but we can file any application for design registration within 6 months from the date of filing in India. So far the period is 6 months, but once India joins Hague Treaty, then you will have more time and very flexible procedure to be used. Thank you.
And also similarly, Dr. Rane, as
Thank you,
copyright,
Dr. Kardam,
as regards copyright, similarly,
for giving
there is
this.
a Vienna Convention, and India has now become a signatory to that. In copyright, unlike for trademarks and patent, once it is filed and countries is a signatory to the Vienna Convention, then it is applicable in all global jurisdictions. You do not have to file an application for that specific copyright in any other jurisdiction. It is enforceable everywhere.
Yeah.
This is a new development about last year in copyright sector.
Right.
And I would like to, rather, Dr. Kardam has very nicely and very vividly illustrated in respect of opportunity for universities in IP matter. Can you imagine? I am just saying data of around 2016. In US, these products based on out-licensing of patents from universities was to the extent of $80 billion. Just imagine the potential
Yeah,
of IP generated by the research institutions, and millions of jobs are created out of research efforts of the universities. And one patent, I tell you, was sold at $3.2 billion, which was a drug patent by Wisconsin University. This is the potential which universities do have, but somehow it remains untapped in India in particular.
Now they have to realize and recognize this fact.
Exactly. Let me tell you one very simple example. India, as you know, in pharma sector, is a generic hub in the world. Generic hub. Do you imagine, has there been any single new chemical entity from India? Answer is no.
So,
Why? I think Dr. Kardam can elaborate on that. That's a commitment. Commitment and not expecting returns on investment immediate.
But look at the small country like Israel.
Yeah.
And even Japan is very small. India-wise and population-wise also.
Many NCs.
They are developing a new MNC every time.
But India, let me tell you, some of the companies like Glenmark and Sun Pharma, they do have a rather exploratory research activities. But once a chemical entity is initially observed to have some potential, but chances of it getting graduated to drug are maybe 30%. They just license to multinational companies. They don't want to spend money on clinical trials.
Now Indian companies are also becoming innovative companies. Slowly, they have also realized that although the new chemical entity may not be possible, but they are coming up with new substitutes or new, derivatives.
Only compositions, not derivatives. Only in compositions they are coming.
So they are now realizing, and now they are sparing some budget for this kind of research. Yeah.
So that's a fact.
Yeah.
Sir, when we talk about the technology sharing, what is the scenario of India, particularly Indian business organization, particularly while protecting their own IPR?
Is it me or Dr. Kardam?
I'm unable to understand the question. You are talking about the licensing out of India or licensing of technology or protecting? What is your exact question?
The question is like this. Particularly, for example, there is an automotive company manufacture a car. This automotive company have a strategic partners who are the key vendors. They are supplying the assemblies and the sub-assemblies, and they have their patented technologies for these assemblies and the sub-assemblies. So when these act as the partners, and there are great possibilities or requirements also, situation demands also for the technology sharing. In that case, how the IPR is protected?
At international level, there are like patent pooling. Patent pooling is a new term where people share their patents. So what is happening if somebody wanted to wanted to manufacture that particular product, because one product may have, it is not like drug patent where only one patent may be sufficient for one product. So, but in other field of technology like electronics or maybe manufacturing sector, maybe computer, software, the related invention, or maybe some mechanical devices where there are a lot of many patents, one product consisting of many patents, or this patent may not be owned by one single person, it may be owned by one person, the several patents may be owned by different people. So what happens if I can't work, if my product cannot work without Mr. Segal's invention, then I will either go for a license to Mr. Segal and pay some royalty, or Mr. Segal would like some patents to be assigned to him so that we both of us can start manufacturing and share the technology. So there are, ways. There are law in India, in Indian Patent Act also, there is provision for this kind of sharing the patent, where if my patent cannot work without the patent of Mr. Segal, then I can request him and we can cross licensing. That is known as cross licensing. So that kind of, provisions are existing in several countries, and the patent pool is working on the concept of cross licensing technology. So these are the ways where the other companies, those who are supplying other part which may be patented technology. So that is how the system is working, on the basis of sharing the, profits, maybe sharing the licensing fees or other things,
Thank you, sir.
This is a very specific thing, this cross licensing. In India, as Dr. Kadam said, that there is a provision in the law. In US, there is a provision that is Sherman anti-competitive law, wherein if any party has got a patent without which other parties' business is getting impacted adversely, and he cannot rather carry on his business, then if at all the party does not agree for cross licensing, then one can go for compulsory licensing under Sherman and competitive law.
Yeah. So same in India, if somebody is not willing, then there is a provision under compulsory licensing.
Yeah.
Same here.
Okay. Thank you. Now there is one more question. Sir, there is a criticism about too much time taken for grant of patent in India as compared to US and EPO. What are the steps taken by the government to address these issues?
So, as you, Dr. Rane, because earlier, when I was there, we made one study where we found that India is taking around 72 months, 72 to 80 months, to grant patent, where Japan was taking only 11 months and US was taking somewhere 18 to 20 months, and European office taking around same time, 2 years and like that. So then the government decided to do away, how to reduce this time. So one approach was that to recruit more patent examiners. So in 2012, we recruited examiners, around 460 patent examiners. And again in 2016, we recruited around 200 patent examiners. And in 2018 also some 100 examiners we recruited. So that is how the one, and then we trained those examiners at our institute at Nagpur, and after training they were inducted in the work. So now, so that is how this entire time limits have come down now. Earlier it was 72 months. Now it has come down to, in the chemistry it has come to 20, maybe 12 months to 24 months anytime. All chemical cases of pharmaceutical, they are being examined within 1 year to 2 years from the date of filing of the request for examination. So it has come down quite heavily. And similarly in biotech related invention, the same, 1 year pendency is there. In computers and related invention and electronics, I think still we have more, around 36 months to 3 years around from the date of filing of the request. and same in the chemistry. But by next year, March, when I was there, we had a plan to bring this time entire in all field of technology to not more than 18 months. So hopefully we have reached in two field of technology that timeline in the chemistry and pharma and biotech. But still, the IP office is trying very hard to reduce this time to 18 to 24 months in other field of technology. As far as trademark is concerned, actually the timeline earlier they used to take 30 months to issue first examination report. Now it has come down to 30 days. So, but I don't know about this the pandemic time whether the same timeline is maintained or not. But it was maintained within 30 days from the date of filing of trademark application. You will receive a first examination report. So this has again has been reduced by appointing more trademark examiners. Similarly, in the copyright, when it was with the Ministry of Human Resource (HRD), it used to take 30 months time to get the copyright registration. Now the same, and within 3 months now you can get the copyright registration when it has come to our office. So the copyright office also now streamlined very nicely, and the design, although design law provided you should get the first exam, your design registered within 6 months from the date of filing, but they used to take 2 years or in opposition matters or opposed matters it's more. But this report first action now issued within 1 to 3 months, and I think our the office is now further streamlined into ensure that most cases the design registration is done within 6 months when there is no opposition, when there's no objection by any third party. Thank you.
Sir, with reference to the examination process of these applications, will you please give some inputs, some precious inputs which are not easily available in the documents, particularly which care we must take while filing the application?
When you file patent application, you must see that the complete when it comes to patent, you file a application and duly signed by the authorized person, or then it has to be filed along with the complete specification or provision. So it can be filed either provisionally, then if you have filed provisionally, then within 12 months you have to file a complete. So complete specification has to be filed within 12 months. So then some people, they wait for, they don't know whether the request for examination can be filed together or not. Some people, they delay it because in filing the request, because the examination of the application is done on the basis of request for examination. So my suggestion is that when you file a application, you must also file a request for examination. And when you there are also provision for early publication, because every application is published after expiry of 18 months. If you are interested to file early request for publication, then you must use this, because once the application is published, if your invention is infringed by any other party, any third party, you are entitled to get the damages from the date of publication of your application. So date of publication is very, very important, and so people must go for early publication. And another important is that now there is a system of expedited examination. So any individual applicant or a applicant who is selecting Indian office as a ISA, IPA, or any institution which is financed by the government, or so they are all entitled. Like for the expedited examination of the patent application, or where the applicant is a woman, that kind of applicants are also entitled for expedited examination. When the applicant is a startup company or small scale industry, MSME, though all these applicants are entitled for expedited examination. So the benefit of early publication and expedited examination should be availed of by the people who are entitled to get this. So people are not aware about this kind of facility being provided or being promoted by the government. For when you take a normal, you file a normal application, you get patent maybe around within 3 to 5 years. But in case of expedited examination, you are granted patent within any time between 90 days to 6 months, or maybe less. So you must take this advantage. Another, how to prepare the complete specification. There are guidelines on our website. The booklets are given, but it better to take the help of a agent or a good qualified attorney who can draft the patent application in a better way, so that, or because drafting is a very skillful work. I think that Dr. Sehgal, he has been doing for a very long time. So he knows better than me, because we always object to certain things where he is working and he is filing. He has good, so he may throw some more light. What are the important things to be kept in mind while filing the patent application?
Yes, sir. Thank you so much. Now, naturally, the question is to Dr. Sehgal. Sir, what are the points to be considered while filing the patent, drafting the patent, and particularly what are the common errors, common mistakes done by applicant while filing the patent?
I tell you, drafting is something which is very, very important in making a very, very strong document for which you can certainly be sure, yes, it will get a grant. One thing is, you must search for a most relevant prior art. As you know, patent law says novelty, inventiveness, and in inventiveness, one very important aspect which I discussed in detail is obviousness. You have to ensure that you rather capture closest prior art to the invention for which you want to file a patent application. Try to identify shortcomings in that prior art to which your invention provides a solution. And in a very descriptive and vivid manner, say that this invention, whatever the technology, whatever provision you are applying for solving, providing solution to that problem, they are not obvious to a person skilled in the art. Taking into consideration these aspects, one has to plan the drafting strategy. And as Dr. Kardam rightly said, there are guidelines. Those guidelines are, there has to be clarity in putting it across to the examiner. And there should not be any uncertainty in the language which you use for drafting application. There should not be uncertainty at all. It should, whatever you're saying, should be very certain. And it also should provide enablement to a person skilled in the art to practice whatever is being claimed by a drafter. So these are the important factors which one has to take into consideration while drafting the patent application. As you know, in a patent application, claims is your property. How many breadth you can have in your claim is a very, very important factor. And breadth should not be unrealistic, which can be challenged, can result in revocation of the patent. All those things one has to take into consideration and plan the strategy accordingly. And as Dr. Kardam has said about, very rightly said about the time taken during the prosecution of patent in India, let me tell you, in US, Dr. Kardam, you probably can elaborate on that. In US, there is a provision under Section 156, wherein, if at all, there is a delay in prosecution and grant of the patent by the patent office, then accordingly, the patent
Right.
term extend it. But I don't think there's any such provision in India. I have written an email, Dr. Narinder Sabarwar, who is a chairman of the FICCI IP committee, and he is the ex-director, deputy
Deputy
director,
Director General. Yeah, yeah.
ex-deputy director of IPO in Geneva, representing India. I personally have written him emails requesting him, why don't you provide such provisions which can certainly make some persons who primarily might be responsible for delay countable, because patent office has to extend the terms accordingly to the patent term to the according to the patent. So this provision is, I think, is not there, which is there in many other countries. In Europe is also there, but in US, many patent you will see there is a rather extension of the patent term by X number of days, which are worked out that delay has been owing to some inaction by the patent office, not by the patent applicant.
Now recently China has done it.
Yeah, it is.
Recently China has done it.
And I would like to elaborate something which is very important. That is PPH, Patent Prosecution Highway. This is something which has recently been, I think India has not probably become part of it as yet. You know what happened
No,
is,
it is on the trial basis with Japan.
yeah,
is.
Japan is there. This is something
India and Japan. Yeah.
which has expedited patent rather prosecution in many countries, because any patent application which is filed in various jurisdictions, it has to undergo examination at each jurisdiction separately. They have to do it right, and one of the important, I would say, factor and the main job of an examiner is to find the prior art based on which one can object and reject. Here in patent prosecution highway, many countries, they have decided to share among themselves the prosecution details with each other. Supposing if the patent application is based in India or US, it's the first priority. It has undergone examination there. Later on, after maybe there's a 30 months time, maybe after 24 months, it is filed in Japan or Korea or Europe. Then it has to undergo examination right from scratch. Under prosecution, patent prosecution highway, these patent office, they have got an agreement among themselves to share the prosecution details with each other, so that the workload gets reduced and examination gets faster.
Dr. Sehgal, I want to just correct here. It is not just sharing of the prosecution. Sharing the prosecution is still there in our act, where the examiner can ask for the information about the prosecution details in the corresponding country.
Yes, Dr. Session-8 provides that in India. But you're very right. Section-8 is made compulsory for that.
PPH is regarding the prosecution highway, means that if the first office of the has granted the patent, let us say the first office is the Japan. If they have granted a patent, then on the basis of that grant, they can request India to grant a patent based on the grant by the Japan. So similarly, if there is an application by Indian, if the Indian office has granted a patent, then on the basis of this grant, Indian applicant request JPO to grant patent on that. So that means the basis of the first grant, the applicant requests second other office to grant patent. That is the patent prosecution highway. It is not just sharing the prosecution details. So there is a ground for granting the patent expeditiously on the basis of grant by the first office.
Yeah, it rather brings in uniformity in assessing the merits of the patent. It brings in uniformity also.
So now this scheme is now being run in India on trial basis between India and Japan. Once the outcome are encouraging, see that if Indian have taken advantage, I have written to the Controller General saying that since India has already introduced expedited examination I'm sure many applicants would have got the patent prior to patent being granted by European Patent Office, USPTO or Japan. So on the basis of our grant, they can request for early examination in those countries actually. So, but I suggested a website exclusive page where all these details should be available to the Indian people actually. So let us hope what he does, because he now going to, his term is going to end on 15th of November. Maybe when the new controller general comes, then only I think some decision will be taken. Anyway, I will apprise him about these things. Yeah.
Sir, with reference to the patent and IPR filing trends, what are your observations with reference to all these trends in IPR world in India and world? So question is for both the speakers.
So
What are the observations?
because Mr. Sehgal is filing the patent application, so he has a much more experience. But I always look at the figures. I mean, I read the reports of various officers, especially the WIPO publication. Regularly, I come across. So now mostly, more than 65% applications are filed from Asia. I mean, Asian. Only 40%, maybe less, are from other part of the world. And so the main contributors are China number one, and number two is Japan, and Korea third. Then comes India. So India is third in terms of filing of the patent application. So, Japan now, last year they filed 13 lakhs patent application, 11 lakhs design application, and around 14 lakhs utility patent. So, just see their potential, how much IP applications are being generated in three fields: inventions, utility patent, and industrial design. So maybe it is around 40 to 45, around 40 lakhs application in all. So in Japan, it is around 2.5 lakhs application every year, and Korea also somewhere 1 lakh applications, and we get around 52,000 patent application, out of which earlier, now last year figure I don't know, because but the year before it was 35% from Indian applicants. So now the Indian application now growing, but in Japan around 85% application in Japan, and similarly in China also 85% to 90% application out of 14 lakhs patent application, they are from by the resident. So here, although India number, not that big, but Indian applicants are the Indian applications are increasing now because of the awareness and various steps taken by the government. But actually, this 50,000 odd applications does not reflect the entire potential of India. India is more innovative country, but it doesn't reflect their true nature. So we need to organize awareness programs and motivate the people to file more patent applications. Look at every year, as per I am sure that around 2 lakhs to 2.5 lakhs research papers are published by Indian researchers every year. You may be knowing better, Professor Hane. But suppose out of 50,000, 30, let us say our 40% applications, suppose 20,000 applications from India. So if you look at the comparison, 2.2 lakhs research papers, only 20,000 applications. It is not even 1/4. Is only 1/10. So unless we convert those research papers into IP application, even we can convert even 1/4. I think that would be a great thing to happen actually.
Thank
I
you.
think maybe sometimes it happens so that researchers are apprehensive not to go for patent, maybe the cost factor. That might be the factor.
Yeah.
However, there is a provision. It's not necessary that you rather get it examined initially. There is a 12 months time.
Yeah.
You just get a only publication in the form of publication by only not applying for a request for examination with the expensive factor. You pay minimum because an innovator has to pay 1,600 rupees as a patent application fee.
Yeah.
If and 1,600, your document, your paper publication, your research effort, they get into public domain in the form of a patent. I think it's a good thing. Maybe it catches someone's eye and he may approach you for licensing.
Yeah.
You get an opportunity. People are not aware of this kind of factors. They say, no,
Even patent filing,
only
patent,
publications.
patent filing doesn't stop you from publication of a research paper.
Yeah.
Next
Yeah.
day you publish. Next day, maybe you ask your publisher to hold it.
Yeah.
When the application is filed, everything is ready.
Exactly.
Or maybe that day you can publish it in any paper.
Because many companies files patent application only to create prior art.
Yeah.
Only to create prior art so that they cannot be barred from practicing it in future. They are
Yeah.
not interested in getting the patent prosecuted and granted. Only for publication.
But if it is published in the form of patent application, somebody else cannot patent your idea. You know?
These are creating a prior art. Not
Yeah.
they can bar you.
Yeah. Absolutely. You are right.
Yeah, these are the factors which unfortunately these scientists in India are not aware of. Because of ignorance on these aspects, they are practicing publication, the journals, as in the past. And moreover, let me tell you, we were talking about technology transfers and licensing. Now there's a provision in WIPO itself. When you submit a patent application, I think Article 54 or something, I'm not too sure about it. You can request them to put in the list of available for licensing. So
Yeah,
that
they have come up with the
or WIPO comes with this facility. If you wish to license out your patent, whatever for whatever you have put up as a PCT application, it automatically gets published among the list of patents in WIPO site which are available for licensing.
absolutely.
That provision is also there now.
Now they have come up with a separate database
Yeah,
for this kind of thing. Yeah.
yeah, that provision is there, but people are not aware of, unfortunately.
Sir, there are some questions in the chat box also. One of the participant, Yaya Narvel, he asked, can we patent system architecture? For example, IoT architecture. The technology is always available, but you can leverage in multiple ways. The architecture can be unique in that sense. How do we get an IP for our work? This is the question in the chat box by Yaya Narvel.
Yeah. Can we patent system architecture? See, our system, as far as system architecture is concerned, I think one need to explain whether it is going to, in what way it is going to have an improvement in the existing product. So if the architecture, system architecture is just a kind of design, then there is a good way of protecting the copyright, system architecture. If it is a device or a flow of some, a process by which you are going to operate a device, then one has to see what is the end product of this. So, depends on the technology, how it is going to be introduced in a particular product. A system architecture may be helpful in improving the functionality of the product. Then we have to say that there is a technical advancement. So one has to look at it, what kind of technical advancement is made. If it is just a, architect design of flow diagram, one has to look at it. So depends on the contribution made by individual. So there is no clear answer I can give, but Mr. Sehgal can give. So maybe a patent will depend the kind of contribution made by the system architect.
It all depends whether it meets requirements of industrial applicability, novelty, and inventive aspects. Those factors are only if at all it is relates to the design per se. Its applicability in industrial application. That is one of the prime factor which will be a deciding factor whether it can be considered for patent or not.
Right. So,
Industrial applicability, whether it can be integrated in industrial application. Then only.
So if it is just a architecture design similar to the architect design, then it is a material for copyright or maybe
That's a copyright unless it has industrial applicability.
Yeah.
So there is one more question. The question says, sir, I would like to know that why patents are not examined before publication.
Not examined before publication. Earlier we were having a system, of filing, and thereafter no request was necessary. So in 2002 we studied the system and came to know that some people are not even bothered whether their application is examined or not. So whether just they have any intention or to repeat the process or commercialize it. Then we found out the system being followed in other countries to promote. So then we introduced the deferred system of examination, that means examination by request. So the system started. So publication, earlier our publication were two types. The first was that just a small detail of the application filing being done within a month or two from the date of filing. There was no fixed time, And then when the patent application was in order for grant, then it was published, and within 4 months or from the date of publication, anyone would file a opposition to that. That was a system existing prior to 2002. In 2002, the system was changed. So the 18 months publication, how the 18 months time was calculated and why? Because that Dr. Sehgal explained to you about the PCT, where the PCT application can be filed, international application, the PCT within 12 months, So that means if it is published, it becomes open to the people, So your chances of filing the application abroad are less. So that is how the 12 months time to that. And there are some time taken by the office in correspondence with the PCT, WIPO and other things, This is being done not only by India, but all the member countries of WIPO and PCT, they do it. And in the meantime, there is an international search report prepared by the Internet Searching Authority and all. So it takes 3 months time to produce international search reports. So it is around 15 months, and then they take the preparation time for 3 months for publication. So it is all about 18 months. So considering the international scenario in the interest of the applicant should not suffer by just publication of invention early before unless he desires it, So that is how, or because if it is examined before publication, then there may be a certain application the examiner is going to miss, as a citation. Some applications are filed, but they are not published, but examination started. So examiner will not be able to find those prior art or contained in those applications which are not published. So that is the reason why the examination will not be meaningful examination unless the application is published.
Yeah, I would like to cite an example. In my case, in particularly, let me tell you, we had filed an application that's on the chemistry process in 2019. Can you imagine in India it has been granted? PCT application was filed by EPO as a search authorities. ISR has come, but the application PCT has not been published as yet. There's a live example I'm telling you. So we are responding to this ISR under Article 30.
But your application must have been published in India at
In
least.
India, it's published, yes, but
Yes.
in PCT it is not published yet. In India, it's been granted.
That means
Why not published in India? Because we have submitted Form 9 for early publication. That is why. In normal practice, maybe it would have not been published by now. In normal
But I
time.
think WIPO doesn't take much more than 18 months.
It's not published yet. WIPO is not published yet as of today. And we have got an international search report. And this week, my response under Article 34 is going to WIPO.
Okay.
And I would like to point out one thing more. Since we have been discussing on this prosecution, PCT also has also got a system. They issue an international search report. International search report is issued by a search authority. India is one of the search authorities now. There's a provision that you can amend the claims taking into consideration the international search report without cost. Else, you can respond to the international search report requesting for re-examination under Article 34. Claim amendment is under Article 19. Under Article 34, for which you have to pay a very high fee to the extent of $3,000 to the WIPO, it can be re-examined and it can put on the record. Those records can be taken into consideration by the respective other jurisdiction while examining your application. I'm just giving an example. Since you said publication, PCT application is not published as of today, but we have received an examination report. It is an exceptional case.
But it is surprising. It is surprising for me. But WIPO has not yet issued the publication.
Yeah. I checked up this patent scope, patent office putting application number. It's not on record yet as a published document.
Okay.
Thank you, sir. Thank you very much. Now we have one more question. Gayatri madam asked, unlike patents, copyrights are established universally. So like patents have limited time, that is, they need renewal. Do the copyrights require the same? It is in the chat box.
I think for copyright, there is no system of renewal of patent, renewal fees payment, So it is, once the copyright is, already, term is there for 60 plus life, So there is no renewal fee system in the copyright. It is automatically established, even if you don't register it, So the copyright system is slightly different than patent. Patent, trademark, you have to renew. For patent, every year up to 20 years, you have to renew except initial 2 years. Where trademark, you have to renew for every 10 years. And in the design, renewal system is there for 10 years plus 5 years. But in copyright, there is no renewal payment system.
There is one more question asked by Shashikant. Can we apply for expediting the examination?
Yes. One can apply for expedited examination, but there are qualifications. The eligibility criteria for expedited examination, where some of which are as follows. Number one, if the applicant is a startup company or applicant has selected Indian office as a ISA and IPA.
Yes.
And applicant is a small scale industry, or maybe a applicant is a woman, or applicant is a government institution financed by the government, or maybe a R&D department of the government, or there are certain more institution and undertaking, central government, state government, department registered under Companies Act. So there are a whole list of eligible applicants who can go for expedited examination.
Thank you. Thank you very much. Is there any question to be asked? Any
Sir,
question?
Rani sir, I am
Yes, sir.
asking.
Yes, sir.
Yeah, sir. Very good evening. One and all, I am Dr. Nilesh Avtis from GH Rajaswini College of Engineering, Nagpur. Sir,
Good evening.
I filed 12 patents recently. Indian Patent Office granted me patents, but I'm asking one question to you. It requires much more time. I filed patent in 2012, and in 2020, this patent is granted by IPR office to me. So that's why this year I set my minds and I would like to file patent of innovation through Australian country. So kindly bifurcate and differentiate between the patent of innovation and Indian patent, because it take much more time. That it around take 8 years for granting of the patents. Would like to commercialize this machine, would like to licensing of this machine, but it goes much more time during this span, 8 years.
Dr. Nilesh, I mean, the taking time of the, I mean, as I said in the my talk, that now we have improved the manpower, recruited more people. So now the grant is much faster than what was used to be earlier, you know. So now the system is now taking less time. But I didn't understand what you mean by Austrian offices, something like that.
Yeah, recently we see some of the patent about the patent of innovations. So I don't know what is my patent of innovation and how the Australian government are granting such kinds of patent within a 3 months and 2.5 minutes. Myself also appear for the patent attorney exam. Recently I studied for this examination. So that's why such kinds of query come in my mind. So
various offices of various countries announce certain schemes, you know. So like if you are aware about the scheme announced by Austrian Patent Office regarding some innovations, so maybe I don't know whether they are utility, they call a utility model patent or a small innovation, something like that by different name. But you know, all these patent or small innovation or utility model, they are enforceable within those countries only. Suppose you have no potential business in Austria, there is no point in protecting in Austria, you know. If your interest potential lies in India, then why you protect in Austria? If your potential interest of your product is in somewhere in United States, then why do you need in protect in Austria just because they grant in 3 months? So that is not your purpose. First you analyze where the potential market of your innovation. Then you take a call where to protect.
Okay, sir. Thank you. Thank you.
Thank you, sir.
For
Thank
the question.
you.
Sir, we are very much thankful for your precious inputs. Now this is the time to summarize.
Sir, I would like to add one thing. मुझे एक कहावत याद आ गई. पहले टीचर्स को कहा जाता था कि publish or perish. That means your number of publications should be more, otherwise you perish. Now it has changed. अब publish और perish change हो गया है. अब हो गया है कि first patent, after patent prosper, and then publish.
Yes.
Otherwise you perish. So अब तरीका change हो गया है. पहले जो publish और perish कहा जाता था, now it has become patent, prosper, publish, otherwise you perish. So now it has that is the new change that has happened now. Thank you,
Dr. Thakkar, excellent remark and very important remark for everybody.
Thank you, sir. Thank you.
So this is the nice time to summarize the session. I request Mr. Piyush to summarize today's panel discussion in few minutes, and then we will move towards the valedictory function. I request all the participants to be over here on the meeting for the valedictory function. Yeah, please. Piyush.
A very good evening to one and all. It's the fifth day of the IPR sessions that we're having, and this was the eighth session on panel discussion on optimization and further streamlining of IPR registration and granting by Dr. K.S. Kardam and Dr. C.K. Sehgal. Within the past 4 days, we have learned a lot in the following sessions by various speakers. And this time, it was about the questions and the doubts which we had, which were discussed by professionals. And some of them were, as Dr. Rani introduced the panel, how to promote IPR in academic institutions, which, according to me, I guess is the most important thing for the prosperous nature of our country. As said by the professors, but there is a lot of potential in students, the universities, and with good guidance and importance of IPR, I guess will go a long way. As in Japan, steps for audit of university, as Dr. Kardam mentioned, we should take precautions while returns, policy, and we should first prepare an inventory. Then there are kinds of intellectual properties, which includes patents, trademarks, copyrights, designs, and many more. Then there were various questions which were answered by both Dr. Kardam and Dr. Sehgal. As included, the government is also helping the institutes, universities, and industries. In 2016, Government of India introduced National IPR policy, which creates awareness amongst various institutes. And then there was another important question raised by Dr. Rane, which was how do we protect intellectual properties abroad? That is generally what most of us do is see of publishing it in our country. But when we go in a foreign land, we first have to publish it in India, and then later, after 4 weeks, within a year, we have to file an application. Then, unlike patents, copyrights are also published. Copyrights are established everywhere. So I hope, like Japan and Israel, we consider them as model nations, and India will also strive towards excellence. Then there were various steps and mistakes which Dr. Rani asked about, and some of them which were answered that should not happen while filing a patent is that we should practice them, we should gain an authorized signature, and the claim which we put forward should be realistic. That is, it should not be challenged by any person. And then there were various questions asked by our participants, which were answered by both of our speakers. I thank both of them for the tremendous knowledge that you have given. And I would give my mic to Dr. Rani sir for the valedictorian.
Thank you, Mr. Piyush. Now this is the time for the valedictory function. First of all, we have with us our patron, Dr. Murdi, Principal of Sardar Patel College of Engineering, and Dr. Agrawal, Principal of Government College of Engineering, Rewa. So I welcome both of them. Sir, warm welcome to both of you. We also have Dr. Tiwari as a TechWhip Coordinator, Government College of Engineering, Rewa. He already joined. And the head of the departments, Dr. Umare, head of the Department of Electrical Engineering Department, Dr. Anupa Sabnis, they also joined us. I welcome everybody. Now I would like to request Dr. Hansa Jeswani, Faculty of Sardar Patel College of Engineering, to give her inputs with reference to the overall workshop. Yeah.
Thank you, sir. Thank you. It gives me great pleasure to give the summarization and the inputs regarding this workshop. First of all, I would like to thank Principal SPC, Professor Murdi, Principal, Reva Engineering College, Professor B.K. Agarwal, TechCube coordinators of both the colleges, Dr. Dhatonde and Dr. Tiwari, and the coordinators of the workshop, Dr. Rane and Dr. Bhole, for coordinating this workshop on intellectual property rights and innovations. And apart from them, I would also like to thank Mayank, Munal, Piyush, Akshit for smooth running of the workshop. I would like to extend my vote of thanks to today's resource persons, Dr. Kardam and Dr. Sehgal, on panel discussion on optimization of and streamlining IPR, in which they discussed how to improve the culture of intellectual property rights in academic institutions, how to file a patent, copyright, trademark, do's and don'ts related to it, patent pool, cross-licensing, and they answered a lot many other questions also. We have had like 6 days and eight sessions which covered all intellectual properties such as patents, copyrights, trademarks, IPR in the digital world and in industry, and it was followed by a session by a young doctoral fellow. The total experience of the dignitaries who delivered in this workshop was more than 110 years. And let me tell you, it's said that if you have an experience or a practice of 10,000 hours in any field, you become a genius. So just imagine we have had the gist of the experience of all these speakers. I'm sure we all gained a lot through this workshop and would try to put our students' innovation in the form of intellectual property in the next coming year. I think so every teacher who is there here can at least put one IPR from their college. And I'm sure all of you would do that, at least by the end of next year. It might be just you or with the help of your college or with the help of a lawyer, as Dr. Kardam has pointed out very correctly, that you have to have a IPR system working for your college, so and give incentives to teachers or to professors who are going forward with filing of patents. It's actually heartening to know that there are students from our college who have filed patents on their own without even help of their professors, but we have given no incentives to them. So it's time that we come out of our cocoon of maybe the easy cocoon of being where we are and move along with other countries. Thank you once again to all the dignitaries, and I thank everyone present today, including the HODs of mechanical and electrical. Thank you.
Thank you, madam. If any participant want to give the feedback, we are open. Otherwise, we will move to the next turn. Yeah. Any participant? Dr. Thakkar?
Yes, sir. I would like to give my feedback.
Yes, sir.
Actually, this was a subject which was an elective in my LLB, and during LLB I could not study it. But now, after this FTP, I think that gap has been fulfilled. And over these 5 days, I have learned a lot of things about the Patents Act, Copyright Act, trademarks, and many things that I had missed during my LLB, or I could not study as an academic subject, because it was my 3 years LLB, while this subject was taught as compulsory only in 5 years LLB. So I think I have breached that gap because of this session, and it has improved my knowledge in this area or this specialization also. Thank you, sir. Thank to all the speakers also, and thanks to Dean sir, Rane sir, for bringing so many eminent people together for our benefit and for enlightening us. Thank you, sir.
Thank you, sir. Thank you for your valuable feedback. Today, we have successfully completed this national level workshop on strategic issues in IPR and innovation, which is jointly organized by Bharatiya Vidya Bhavan, Sardar Patel College of Engineering, Mumbai, Reva College of Engineering, sponsored by TechPip 3. We had eminent speakers from different backgrounds with us for this 6-day workshop. The workshop has covered the topics like introduction to IPR and patent filing practice conducted by C. Naveen Andrew, Deputy Controller, Patent Office, Chennai, Government of India. Another session was conducted by Dr. Archana Madam on innovation and patent approach for academicians. She is a professor in IIT Delhi. Another session was conducted on copyrights, insights and related strategic issues by Shri Raghavendra sir, is a Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. A trademark and domain name issues session was conducted by Mr. Vikas Asawat, he is a senior legal consultant and patent trademark attorney. A session on IPR in digital world has been conducted by Advocate Ranjan Narula, who is a managing partner at RNA Technology IP Attorneys. A session on innovation and IPR strategy in industries was conducted by Dr. C.K. Sehgal, managing partner at Sehgal RPR Services. A session on journey of research was conducted by Jaya Madam. She is a PhD scholar at University of Bristol, United Kingdom. And a panel discussion on optimization and further streamlining of IPR registration and granting that was conducted by Dr. K.S. Kardam, Senior Joint Controller at Patent Office, New Delhi, Government of India, and Dr. C.K. Sehgal, Managing Partner at Sehgal IPR Services. So this workshop has given a lot of precious inputs to all of us. Agreeing to the slogan, teamwork divides the task and multiplies the success. The credit for the success for this program goes to every individual who has put in a lot of hard work in order to make this workshop worth learning. I would like to thank our patrons, Dr. Shesha Iyer, Chairman, DOG SPC Mumbai, Dr. Abhay Wagh, Director, Directorate of Technical Education, Maharashtra State, Dr. M.M. Murdi, Principal, SPC Mumbai, Dr. B.K. Agrawal, Principal, REC Rewa, for their blessings. I appreciate the efforts taken by the organizing team for smooth functioning of the workshop and organizing committee members, HOD, Dr. S.S. Umale, Dr. Anupa Sabnis, Dr. Bage, Dr. Dahatonde, TechWeek Coordinator of SPC Mumbai, TechWeek Coordinator Dr. Tiwari from REC Rewa for their time and efforts. I want to specially thank Dr. Kiran Bhore, Dean Research and Development, SPC, for coordinating the workshop along with me and helping the student organizing team to work efficiently and effectively. I want to thank the student organizing team for keeping a track on smooth functioning of the workshop and working efficiently in the back end. I'm also thankful to you, all the participants, for the patient listening. I hope you all have enjoyed the national level workshop. I thank Prathamesh Poddar, research scholar, for managing the YouTube live activity, and also Kashmiri Madam and Suhas sir for helping the team have system related queries. I thank TechWeek office team for giving the necessary support. Now we have the organizing team members. I would like to request Dr. Anupa Madam to say a few words. Anupa Madam. Dr. Anupa Madam. Okay, we will switch over to Dr. Umay sir.
Yes, sir. Yes, sir. Hello. Am I audible?
Yes.
Good evening, sir. Am I audible?
Yes, yes, madam.
Yeah. Good evening, our principal, Dr. Purudi sir. Then eminent speakers, principal from Rewa College of Engineering, Dr. B.K. Agrawal, Dean Academics, Dr. Rane, HOD Mechanical, Dr. Umale sir. Very good evening to you all participants. I'm just going through the chat box when my name was actually announced by Dr. Rane. And after seeing the feedback from the chat box, I don't think there is any need to say about this workshop. I first of all congratulate Dr. Rane and team SPC for organizing such a wonderful workshop. Due to some other actually the involvement, I couldn't attend the workshop, but I have attended one session, that is IPR in digital world. And really, I mean, all the sessions, I am very sure that they must be in par with that session. So I hope that such workshops will be arranged in future, and I'll definitely attend the same. And these workshops will help everyone, like new scientists, then the students, then the teachers, because this is very. I mean, we are having rightly said. I mean, by someone that we are having number of publications in the year, but then as far as the patent is concerned, then we are slightly, I mean, the scared, because it is, I mean, the time related issues and all. But nowadays, I mean, those issues are also getting solved. So I'm very sure that in near future, from academicians also, there will be many patent filed which will be useful for the society, and of course, I mean, for the personal growth also. So thank you very much for giving the opportunity to say these few words. Thank you, sir.
Thank you, Dr. Anupa madam. Now I will request Dr. Umare sir to say few words. Dr. Umare.
Yes, sir. Yes, sir. Very good evening to all of you. I take this opportunity to welcome honorable speakers in the SPC FDP program. My dear students, student organizers, coordinators of this FDP, Dr. S.B. Rane, Dean Academics, and Dr. Kiran Bhore, PhD coordinator, HOD Dr. Sabnis madam, respected principals Dr. Moody, SPC, Dr. Agrawal, Reva Engineering College, TQIP coordinators of SPC and Reva. Welcome all to this program. Every participant learned from this FDP two things. That is, why do you want to patent and copyright nowadays, as well as how to file patent, what is trademark, what are the requirements of filing patents, copyrights, and trademarks. So I think participants got very tremendous knowledge from these different programs organized and delivered by the eminent speakers. I want to give some message to my student organizers and student committees. Dear students, why students require different challenging programs in this college? This is the question I am asking you, because from this platform you learn the challenges, and this is a platform. SPC has created the platform for learning and facing the future challenges to get unique solutions. We require motivation and inspirations to perform such activities. Your participation is important in the prestigious event like this, and hence students must be innovative. They should attend different workshops. They should visit different organizations so that you can understand research, understand the concepts, understand the meaning of technical knowledge you have learned in college and in graduate studies. Always remember success of mantra. So I am giving this mantra for my students committee member. Knowledge is power, work is worship, and you should follow 4Ds everywhere whenever you go to get success. That is, you must have winning personality. First is decorum, second is decency, third is dignity, and fourth D is discipline. All 4Ds are required to get success. Thank you very much, all participants, speakers, respected principals, Dean Academics, Dr. Kiran Bhore, and Dr. Hansa madam. Thank you.
Thank you, Dr. Umare. Now I would like to request Principal of REC Reva, Dr. Agrawal sir, to address the audience. Then after his speech, Dr. Murdi sir, principal of SPC, will address the audience, and then at the end, the vote of thanks will be given by TechWhip coordinator Dr. Tiwari. So I request Dr. Agrawal sir to address the audience. Yeah.
Thank
Agrawal
you,
sir.
Dr. Vade. Am I audible?
Yes, sir, you are audible.
Thank you for giving me this opportunity. In the inaugural session, I was busy with some personal work. I could not attend. I will not take much time, but at this time of Sanchar Kranti, this type of workshop, it was really wonderful. Though I did not attend it, I attended the last question answer session only. But this was a very nice workshop organized by SPC. I thank you giving me this opportunity to speak on. Thank you very much. Thank you, everybody. I will not take much time. Thank you. Thanks all.
Thank you, sir. Thank you for your blessings. I request our honorable principal, sir, Dr. Murdi, sir, to address the audience.
Distinguished speakers, Dr. Kishan Kardam, Dr. Charanjit Kumar Sehgal, for the today's session. Principal College of Engineering, Rewa, Dr. B.K. Agarwal, TKIP Coordinator, Dr. Rahul Datande, FPC, and TKIP Coordinator, Rewa College of Engineering, Professor Tiwari, heads of the department, Dean Academic, Dr. Rani, Dean R&D, Dr. Kiran Bole, participants from various institutes and organizations. First of all, I congratulate the organizing team and participants for successful completion of this online workshop on strategic issues in IPR and innovation. As told in the inaugural session, this program has been organized jointly by SPC and College of Engineering Rewa under TKIP 3. I am happy that such programs are regularly organized one after the other. I came to know that the research portions for this workshop were very senior, experienced government officials, IT faculty, legal consultants, and advocates. I am sure that all participants have been benefited by this workshop and hope the faculty members will come up with more number of patents in future, which will help in accreditation, autonomy, and getting the NIRF ranking improved. We look forward your active participation in forthcoming events. I thank all the resource persons for their valuable delivery. I thank Principal B.K. Agarwal, College of Engineering, Principal College of Engineering Rewa, Professor Tiwari, TQ Coordinator, College of Engineering Rewa, for coordinating this online workshop. I also thank Dr. Rahul Dhatonde, TQ Coordinator, SPC, Dr. Rane, Dean Academic, SPC, Dr. Kiran Bole, Dean R&D, SPC, for taking keen interest and making this event successful. And I also thank all the participants for making this event success. Thank you all.
Thank you, sir. Now I would like to request Dr. Tiwari, TechWhip Coordinator, Government College of Engineering, Rewa, to give the vote of thanks. Yes, sir.
Thank you, Dr. Rane. I'm audible, sir?
Yes, sir. You are audible.
Okay. Good evening, all of you. Respected dignitaries of today's workshop, the online workshop. Really, we have enjoyed it very much for 1 week. Our today's chief guest, Dr. K.S. Kardam, Senior Joint Controller, Patent Office, Government of India, New Delhi. Dr. C.K. Sehgal, Managing Partner at Sehgal IPR Services. Dr. Yamamurthy, Principal FCC, Mumbai. Dr. B.K. Agarwal, Principal REC, Rewa. Dr. Rahul Dhatonde, TKIP Coordinator, SPC, Mumbai. Dr. Santosh Rane, Coordinator of this online workshop. Dr. Kiran T. Bole, coordinator of this workshop, and the organizing committee members, Dr. S.S. Umle, Dr. Anupad Sabnis, Dr. A.K.A. Bhage, and all the faculty members of SPC Mumbai and REC Riva, and all my dear friends which are present at this validity function. SPC Mumbai and REC Riva has jointly organized this 1 week workshop on strategic issues in IPR and innovation. I warmly welcomes you all and give my heartfelt thanks for being you all the important part of this program. Really, I propose my vote of thanks to all my speakers, all my guests of today, and all the organizing team for nicely organizing this program. As coordinator of this workshop, Dr. Rane and also Dr. Piyush has already mentioned that this workshop has 8 sessions, including 7 lectures on different days, and one last session was the panel discussion, which was conducted today. Really, this workshop was very useful to all the participants. This is my hope and this is my expectation. On behalf of organizing team, I express my great sense of gratitude to all my renowned speakers. The speakers we have already named by Dr. Rane. They are all the very dignified speakers, experienced professionals, and working professionals in their field. All the eminent speakers spare their precious time and share their knowledge and experience to us. I again convey our thanks to all my speakers. I also thankful to Dr. Murdi, Principal SPC Mumbai, and Dr. B.K. Agrawal, Principal, Riva Engineering College, Riva, for their gracious presence and time to time their support to make this workshop successful. The members of organizing team and the coordinator of this workshop, especially Dr. Santosh Rane, has put his hard effort to coordinate this workshop successfully. So I thanks to all of them for their tireless hard work. Finally, I thanks to SPA Maharashtra and SPA Madhya Pradesh and NPI New Delhi for their valuable support. I also would not leave the contribution of Dr. Hansa Jeshwani and Dr. Thakkar and Dr. A. Bage, who have given very good input in this workshop as a feedback. And all the participants which were present in this workshop must have really enjoyed. I am again give my thanks to all of them, and I propose my vote of thanks to each and everyone who directly or indirectly supported this online workshop to make it great success. Thank you, everyone. Again, thank you all. Thank you, Dr. Rane.
Thank you, sir. Thank you for the vote of thanks. Now it is the time to close officially. I wish everyone a sound health always. Best regards. Bye-bye. Thanks to everybody. Bye-bye.
Thank you. Thank you.
Thank you very much.
Thank you.
Thank you, sir. Thank you so much.
Bye.
Thank you, sir.
Thank you, thank you, Rane sir.
Thank you, Rane, sir.
Dr. Rane, I would like to rather say, if at all anybody has got any query, they are free to write to me on my email. You can share my email with them. But
Yes, sir. Yes, sir.
anything, I'm always there. Without any hesitation, you please feel free to contact me. Any.
Sure,
Sehgal,
sir.
sir. Sehgal, sir.
Yeah.
Can I ask one query, sir?
Yes, please.
Yeah, is there any concession for students to file patents, sir?
Yeah, and students for filing a patent, there is no limitation. Student as an individual, as an innovator and applicant together can file a patent.
Yeah.
There is no bar in respect of our anybody has to rather qualify specifically for filing a patent. Any student can file a patent as an innovator and as an applicant also.
Yeah.
There is absolute freedom. And for students, in fact, the patent filing fee is only 1,600 rupees.
1,600. Okay. Okay. Thank you, sir. Thank you.
Thank you.
Thank you
Thanks
very
to
much, sir.
everybody.
Thank you.
Thanks to every participant for making this workshop successful. Bye.
Yeah.
Thank you. Thank you.
Oh, thank you, sir.
Sessions.
Thank you very much, sir.
Yeah, okay.
Bye. Bye.
Bye. Have a nice day.
Bye. Bye.